I not only moved in with my 3 kids, but I brought all of my grandmother's antique furniture. We got rid of your modern dining room table.
I still don't like that.
Did you plan for this, or did you miss when life demands answers you can't dismiss? Will you be ready when the trumpet blows? Do you have the blueprint for life's unknowns?
Welcome back to Plan for This. Real people, real stories, real solutions. Marguerite Lorenz is going to read the case study today, and we're going to then discuss it. And after that discussion, we know it's going to impact you in this viewing audience. We ask you to subscribe and become a Plan fan. To get more information, go to planforthis.com. Marguerite?
Lawyerless. Douglas, 76, is widowed with a daughter, Lisa, 50. He has been retired for several years now, having had a government job and associated pension. When Douglas retired, he completed a will, including a testamentary trust, leaving everything to Lisa, including explicit instructions on how to maintain his investments after his passing. Lisa once recommended that he establish a revocable trust, but Douglas has not made any changes to his existing plan, believing the single document, his will, is good enough. Douglas recently had a medical checkup and is in good health. Unfortunately, his lawyer, only 56, was not so lucky, passing away last week. His lawyer's death was not a part of Douglas's plan. Douglas knows he must rethink his plan, as the lawyer was listed as successor trustee in the testamentary trust, and with him now gone, Douglas wonders what to do.
I think there's a lot to unpack there for the listening audience. So the words trust, or what is that all?
Well, let's talk about what testamentary
trust.
Yeah. Testamentary trust means that you, in your testament, you're saying that you want a trust to be created. So I just want you to think about this for a moment. We're talking about a will. And part of what makes it a will is that you're stating, I'm of sound mind, right? This is my wishes, my intention. And you write this document, and you can certainly write it yourself. Your state is going to have some guidelines about how to do that. But I strongly recommend that you don't practice law on your own. There's a reason why we need attorneys. We need them to translate and navigate. We also want them to help us understand the consequences of our choices. I find it interesting that in Douglas's case, his attorney not only assisted him with getting this will completed, but his attorney also volunteered to be the successor trustee in the same document that he created. I see that as something of a conflict of interest. So now the attorney's gone. And the one person that Douglas named in his will to create and be responsible for a trust isn't there anymore. So let's go back to testamentary trust. I'm sorry if I wasn't clear about that. It means that you've given a couple of sentences in your will to saying that a trust should be created and that your stuff should probably go into the trust. But because you don't have a separate trust document, you didn't create a revocable living trust as Lisa had suggested her dad do, that means that you don't have any of the details. You haven't really granted authority to someone to go and find the assets maybe that are not in your trust but should be. And your will has certain tools about it. But here's the thing about a will, it becomes a public document. So when you die, your will gets lodged in the county in which you passed away. It's public notice, right, that you passed. The trust stays private. So if Douglas decides to, he can have a trust where the details, Lisa gets everything, and who's going to be the trustee. And what if that person doesn't live? Oh, well, then there's another trustee and another. So you build a succession plan in a revocable living trust.
So just to clarify, just because I want, if you have again, with a trust, a lot of times comes the will. I mean, they're kind of the attorney will do both of those documents.
Typically, the whole estate plan will be done for you, right?
So if you have a trust, the will then does not become a public document. Or I'm not understanding.
The will is a standalone document that becomes public at your death.
Even if you have a trust?
Yes, but think about this for a moment. When you have the whole plan done and you're working with the attorney, you're crafting how this is going to go. You're not just crafting the documents themselves, who owns what, who gets what, how much money do you have? No, you're actually crafting how your assets are going to get moved along to who you choose and how you might be cared for if you couldn't care for yourself. But the will only operates at your death. So for instance, in Douglas's case, Lisa has no authority to help make decisions for him if Douglas is in the hospital because all he has is a will. Okay? The will is just one tool in the toolbox. Do we need all the tools in the toolbox? Maybe not for every job, but we really want a full toolbox because we never know when we're going to need it. So the will is limited. You can name guardians for your minor children in a will. You can say, if I didn't put it in my trust, I meant to, my executor gets to work with my trustee and make that happen because executor is the name of the person with the job in your will. You don't have to have the same person be your trustee, but it's kind of complicated and messy if you don't. So I want you to think about your estate plan as a toolbox for right now. We're going to make sure that we have all the tools we need to serve us while we're alive and not capable when we lose our capacity, when we're alive and we choose to resign as trustee because we're tired of dealing with all these details and somebody else is going to do the work, and also when we die. When we die, we have tools available for the person that we grant authority to so they can take care of things for us.
So in this case, what is Douglas's decision now?
Well, he's going to have to find a new attorney because dead attorneys don't write any new tales, right? Okay. And I think it's important too that because he wants Lisa to have everything when he passes, at least I read, that's how I read this, right? Leaving everything to Lisa, including explicit instructions on how to maintain his investments after his passing. I'm so interested in what those investments might be. Could it be rental property? Could he have a couple of rentals and that's how he gets his income? And he'd like Lisa to have that income? And what happens if Lisa becomes incapacitated or too sick to manage these investments? Then what happens? So some people might choose, especially in this case, there's a dad, there's just one child. Maybe both of them go visit the attorney. But at some point, the attorney is going to want to talk to Douglas alone to assure that this is Douglas's choice, that this is what Douglas wants for himself. Even if he gets along great with Lisa, and Lisa's clearly healthy and kind and all the things we want an adult daughter to be, still the attorney has to make sure, Douglas, is this what you want?
And that just brings up a great point is for those that have a trust, when's the last time you talked to the attorney? Did you write it 10 years ago, 15 years ago, 20 years ago, and it's sitting up on the shelf collecting dust? Is your attorney still active?
Oh, such great questions too. I will tell you that laws change. The landscape that we're all operating in changes. Congress still continues to meet and tax laws change, right? So because things change all the time, maybe nothing has changed in your life. I doubt that, but it's one of the considerations that you go back to your attorney and say, it's been 5 years, it's been 10 years, and maybe this needs an update. Could you look at my estate and could you look at my trust and my documents and tell me, is there anything we need to update? Will that cost some money? Sure, but it's totally worth it because probate itself could cost 10 times, 20 times what it would cost to have an up-to-date estate plan. And we could probably explain that on another show. But I want to say that for Lisa's sake, that if her dad goes back and finds a new attorney and has a reasonable conversation about what he has right now and what his plans are for maintaining his investments after he passes, both Douglas and Lisa will have a sense of relief, a sense of calm and organization. That just means their relationship has the opportunity to get better and better all the time. And that's really what I'm wishing for everyone.
Well, any other last comments on this?
Don't wait. Don't wait. You really don't know what's going to happen. And for myself, since I got my estate plan done, and it's 20 years ago that I first got my first estate plan done. I want you to think about any estate plan you get done as your first estate plan. And then from time to time, I've hired different attorneys because their lives have changed. My life has changed. Where I live has changed, that kind of thing. And so I found someone that I wanted to work with. And so I've updated my documents 6 times now. I'm in a blended family now. I love my husband. He loves me. We have lots of kids between the two of us. And we come from different places, right? We came with these kids into our life. The sand ceremony at our wedding was particularly beautiful, when we all blended different colors into one big jar. I treasure that jar. Well, who gets the jar when I die? And that's a question, right? So over time, you end up with different questions. You might have started with what happens to my assets and what happens to my babies? Who will take care of them if I can't take care of them? That's how I started. My kids were young. They were 8 and 9 years old when I got my first plan done. And so my big worry was what happens to them if something happens to me? I'm the only parent who looks after them. I'm the only one who cares. So that's what that focus was for that estate plan. Well, as time goes on, they were both over 18. I wasn't so worried about that. Now they're mature young men. Their lives have moved on. Their lives continue to grow. And so from time to time, I revisit my plan. Is it going to serve me if I'm ill, incapacitated, I can't manage? Will it serve my husband? Will it serve my children? Will it serve our children? And so all of those things can change during one lifetime. And that's why you need to update.
Frequently.
Sure. I hope so. Life is big, right?
So if you are part of a blended family, and that's a lot, and you have a story to share, please share it at planforthis.com. Subscribe and become a Plan fan.
Yeah, and we really invite your comments below. If any of this resonates with you, if you're thinking about any of this now, or you have further questions, let's get the conversation going. Let's make sure everyone has an up-to-date estate plan.
Thank you, Marguerite.
Independent Trustee Alliance is a proud nonprofit sponsor of Plan for This. If you are considering serving as a trustee, please visit trusteealliance.com to learn more about this complex and sometimes overwhelming job. trusteealliance.com. Plan for This thanks the Estate Sale Warehouse for all their amazing service and support. Entire home cleanouts, inventory, appraisal, auctions, sale of fine art and classic cars. Learn more at estatesalewarehouse.com.
Up next is our Plan fan submitted question. If you would like to submit a question and a story to us, please go to planforthis.com and become a Plan fan subscriber. Today's question really feeds on our case study and our recent conversation. So, hi, Marguerite and Ron. My husband and I both have children from previous marriages, but none together.
Okay.
We love all of our kids, as we often say, but just as our finances are separate, we plan on splitting our individual assets amongst our respective children. We're certain about our decision, but unsure of how to implement it. What is your advice?
Oh, this is a good one. So just to be clear, this is just as our finances are separate. So I can see the logic of that, right? You've already been divorced. You've already been through that. Many of us have been through that terrible experience, and we don't want to risk it again. And, my dad always advised yours, mine, and ours, meaning you have your own account, I have my account, but we have some kind of mutual account to pay the bills and so on. So one of the questions I would have for this couple is, do you own your home together? Because there's lots of ways to do that. And this is why you really want to talk with an attorney about your options. Technically speaking, the attorney who's going to have an agreement with you both to write a trust for you both, and then each of you would not only be trustees of the same trust, trustors, creators of that trust together, but you'd each have your own will, your own power of attorney, your own advance healthcare directive. But it's possible that each of you have substantial assets. It's possible that each of you would have a separate property trust. So each of you would have your own assets in your own trust that would go to your own kids. But there's still the logistics of living together, paying bills together, who's responsible for that? Because that has value. And that might really matter at some future point. Yeah, maybe.
Maybe. I mean, this is a podcast story because this is so relevant to so many people. Because one of our previous podcasts, we talked about the successor trustee after mom and dad had passed away, about divvying up the personal property.
Right.
The full set of silverware is being split up into five different family members. So this is really an incredibly important question.
Well, let's give this just a little more detail because I think this is really worth spending the time. Okay. Um, we're going to pretend, Ron, husband Ron, wife Marguerite. Okay. We have 5 kids between us. You have 2 and I have 3. Okay. I have a business. You have a business. And we've each grown our businesses. We got divorced some time ago. We found each other. And Ron's just my friend, like a brother to me. But we're just using this as an example. Okay. But it makes it interesting in the sense that, okay, so we have a household together. Maybe all 5 kids made it through high school together, right? I had a senior, you had a senior. I had a junior, you had a junior. And then I have one in elementary school when we got together, right? So the kids grow up, they move out, but we still have the elementary kid now who's just starting college. So those are considerations. How does school get paid for? Our financial history and our documents and so on. There's a FAFSA or a federal application, right, for funding and for assistance with school. So those kinds of things need to be considered. But we'll go back to the trusts. I have a trust, a separate property trust. You have a separate property trust, and we have a mutual trust that holds the house. So maybe when the house is sold, those proceeds get split 5 ways. That would make sense, right? We bought the house together, let's say, and that would make sense. But if you had the house and me and my little family moved in, that might be different, right? That's part of your trust. And that we might need a prenuptial agreement or a postnuptial agreement.
Allow you to live in the home until X time.
So now we get to talk about what that is. That's called a life estate. That means that if Ron dies first and the kids have moved out, I'm in the house, I get to live in the house until I die. And then your kids would inherit that money. That might bring a little tension. Those kids might be anxiously awaiting my death. So there's that to consider, right? So that's another reason why we strongly recommend talking with an attorney. Are you smart enough to do your own plan? Probably. I mean, you know your stuff, you know what you want. That's great. But having the attorney ask questions like, so how do you picture that going? How's that going to work for all the people that are involved?
And I just say, before you even go to the attorney, submit your story to us. And we may be able to give you, not maybe, we will be able to provide you those questions to ask of your attorney. Because I always say, if you don't know the questions to ask, the attorney may not pull out that perfect question that generates the conversation that you have to have.
No, we're just going to be careful and say this. We're not giving any legal advice. Okay, we are not attorneys.
Disclaimer.
But we do appreciate the work that the attorney does, especially when you have an experienced estate planning attorney who's seen a lot of these cases. They've come up with solutions for other people that might work for you. And a lot of us feel that our situation in particular is completely unique. I get that. There is no one like you. I know that. But at the same time, the law has to be kind of broad, right? And there's been cases that people have actually had to adjudicate and figure out and get an answer. Case law changes the law under which we operate. The statutes, our legislators get together and they update the law. And then our lives continue to happen, right? And we have certain assets, and we have certain things, and we want it to go a certain way. So the contents of your home is just as important as the home itself, but those might be 2 sets of different assets. So as one more example of the things to consider, right? I not only moved in with my 3 kids, but I brought all of my grandmother's antique furniture. We got rid of your modern dining room table.
I still don't like that. No.
And the china cabinet and everything. So there are certain items in the home that are clearly mine. This would be the opportunity for us to make that clear. So whether or not you need a prenup, with my husband and I, what we decided, and I'm sorry, Ron, I'm in love with someone else.
That's okay.
with my sweet husband and so on, we decided a prenup was not for us. We did this stuff, this conversation, this figuring out in our estate planning process. And once we were done with it, we felt really confident and fine that our adult children will be fine. They don't have to be worried about each other either, because none of them are going to be the successor trustee. We decided that we want them to get along. So that was a choice that we made. We decided that was so important.
I cannot think of a more important comment to make. If you are a blended family and there's two, three, whatever the case may be, and you give all the responsibility of being a successor trustee to one side of the family, it's just human nature. I mean, come on, even if you all get along and you really like each other, it's just human nature to be a little bit resent. There's a little bit of angst going to be moving into that situation.
Well, sure. And you're expecting that family member to overcome that angst, to be transparent and open with everyone who's involved. And when you end up with more children, sometimes they're married too. So now you're dealing with their spouses and their needs. And that's not a bad thing in of itself, but just understand the pressure you're putting that one person under. And please don't make them all co-trustees, because it's so much worse.
Oh, thank you for saying that. We'll give one on each side.
Oh gosh. Yeah. Really think about the people you love. And if you really love them, just know it used to be very common where the eldest child would become the trustee. I get that. We're all kings of England, right? I mean, that's how that works, right? But the truth of it is that things are much more complex now. There's tax, legal, financial, and even medical issues. There might be a lawsuit going on when someone passes away. You know, it's not just a slam dunk that we all leave the funeral, we all leave the cemetery and go empty mom's house of the furniture and we're done, we're good. No, it's much more complicated than that. So I'm sorry it's complicated. I'm sorry that there's so much going on that it's not just a slam dunk to name one person in your document and be done. You're going to have to give this some thought. And we're here to support that.
I think Plan for This will continue to, this is a big case. I think we'll have our own separate podcast. We'll bring on some special guests to talk about this. Again, one other thing, more and more people are getting divorces later in life as they age, in 50s and 60s and 70s, are getting a divorce.
Yeah.
And then they are finding a partner and they're not getting married. So that even puts another wrinkle into this scenario. So we will continue to talk about relevant topics. So go to Plan for This, subscribe, and become a Plan fan.
Are you a solo ager? Are you living apart together? You each decide to keep your own house, but you have a relationship. You care about this person. How can you be of service to that person if they became ill or they really needed you? Do you even want that job? So being able to talk about things doesn't mean you're going to do that thing. It means you're going to think about it and decide what you want. There's nothing more powerful than being at choice. So I hope you make your comments. I hope you come join us at planforthis.com.
Money management and